Hello, friends. Welcome to Investment Immigration Conversation. I'm your host, as ever, Carolyn Lee, principal and founder of Carolyn Lee Pllc, a U.S. investment immigration law firm dedicated to helping clients build their futures with investment immigration. So today we'll be talking about the upcoming USCIS stakeholder call happening October 19th at 2 p.m. Eastern. For details, please look at the post on our website at carolynleepllc.com. The theme that I hope will run through our quick talk today is going to be the need for meaningful engagement with USCIS, with the Investor Program Office, on the EB-5 program, particularly with respect to the EB-5 Reform and Integrity Act implementation. As we've been talking about, as the entire industry has been talking about for the last really several years, this is a major change in the EB-5 landscape, the passage of a very large piece of legislation just this past March. And we need to proceed with some predictability and with some input, substantive input on the best interpretation of the Reform and Integrity Act, or REA. And the things that we'll be talking about today, I think, will weave various strains of thought in pursuit of this theme for the need for this meaningful engagement about the best way to implement REA going forward. I thought we would unfold this in a few different parts. I thought it would be helpful to have a little bit of history of EB-5 stakeholder engagements, which really involves touching on the history of the EB-5 program itself. Second, I think it's very worthwhile talking about, very briefly, the EB-5 processing times. They're very, very long, and one advocacy point, one point of request in these public engagements and in all correspondence really with the agency, I believe, is the request to focus on reduction of processing times in EB-5. The third thing that we'll talk about is the so-called bearing to settlement agreement. This is the settlement agreement arising from the second litigation brought by Bering Regional Center and other leading regional centers and Invest in USA, or AILA, about RIA implementation. And the terms of the order, I think, will occasion some questions as well. So to fuel those questions and to inform you about the contents of that settlement agreement, I'm going to just briefly summarize the terms of that agreement. All right, how about we just get started? Okay, so the history of EB-5 stakeholder engagements. I remember that they were very new, at least to me, and I had been practicing business immigration for some time before the stakeholder engagements in EB-5 space came along. And the agency was certainly having liaison meetings and dialogues with the American Immigration Lawyers Association, with AILA, but not these more in-depth programmatic engagements about a particular product line, as it was starting to do with EB-5 around 2010, 2011 or so. And I think this is in recognition of the leadership's understanding that they were wrestling with a very, very complex program. And just a brief history of that program that we know and love and use. And I'll note that the very recent policy manual updates discussing the changes brought to the program by RIA cover the history of the EB-5 program in Chapter 1 of the updated policy manual, the section dealing with EB-5, which is Part G. So I recommend that you check out that section as well. The EB-5 program has a permanent component and a component that has to be renewed from time to time, including the program that we're in right now, the iteration of the program we're in right now. The permanent part of the program was a part of a very big piece of immigration legislation that we called IMACT, passed in 1990, where the fifth preference category that we know as EB-5 was first created. This is what we call the basic program today, or the direct program. This is the EB-5 program where 10 direct jobs are required to be created by the new commercial enterprise. Just a couple of years later, in 1992, a pilot program was created by law. That is the Regional Center program. And the purpose of the Regional Center program was to stimulate regional growth and expand the EB-5 program as it was by allowing pooled investments by more than one investor into a project, and permitted calculating jobs based on indirect job creation. So meaning jobs not only held at the new commercial enterprise, jobs not only stemming from directly the new commercial enterprise, but from the indirect impacts of that pooled investment in the region. So that is the Regional Center program created in 1992 that has since needed to be reauthorized from time to time. The 1992 program, the Regional Center program, went on and it evolved until 1998. So at the end of a 6-year period, there was a sea change in the services administration of the Regional Center program. And that sea change was marked by 4 precedent decisions of the Administrative Appeals Unit that came down in 1998. And these 4 precedent decisions are matter of Ho, matter of Sufichi, matter of Sheng, and matter of Izumi. And without going into the details of what these 4 decisions stood for, they effectively greatly shrunk, really, for all intents and purposes, shut down the pilot program, the Regional Center program, as it was carried out at that time, by dramatically changing how the agency interpreted the EB-5 program requirements and applying those changes retroactively to cases that were already in the pipeline and prepared in accordance with the way the agency had been adjudicating those cases. The retroactivity or the application by the agency of new interpretations on cases that were filed under prior interpretation was challenged in court and ultimately ended up being reversed in the landmark decision, Chang versus the United States, which was successfully litigated by my good friends of EB-5, Ira Kurzban and his firm. So even though the retroactive application was reversed in the ringing words, 829 adjudication should have a lot more predictability than was afforded by this retroactive application. The court ruled that 526 approval should be an excellent predictor of 829 approvability down the road. So these are very important principles that help us today in checking the potential retroactive application of new agency interpretations. Very important as we're looking at a very big body of changes brought by the RIA. So the precedent decisions greatly shrunk the EB-5 program, as I said, until around 2006, 7, 8, the first decade of the 2000s. And I remember when the immigrant program office issued letters to the existing regional centers, which at that point numbered only around 20, if you can imagine that. Now they're in the hundreds, 600 or so by last count. And these letters sort of checked in with these existing regional centers and asked what they were up to and whether they were still interested in keeping their regional center designations. And this was really an indication that the agency was interested in the program again, interested in regional centers, and possibly interested in reinvigorating the regional center program. And indeed, that ended up happening. And the agency, by agency I mean USCIS, stood up a dedicated unit for EB-5 administration, and officials of the new unit began reaching out to regional centers, visiting a number of them, and all of this dovetailed with the Great Recession and the need that developers in the United States were feeling for the need for capital, since the other traditional credit markets were no longer really lending capital. So these two events led to a resurgence in the interest, in the activity of regional centers, and that came together with a resurgent demand in EB-5 as well. So these events all sort of came together, and we began to see a fairly rapid, robust growth in the EB-5 program, all the way up until 2015, 2016, with the changes that were brought by discussions about really substantive changes to the program, including major investment amount increases. So that kind of brings us to where we are today with the passage of the Reform and Integrity Act and the revival of stakeholder engagements under new leadership at the IPO with this new law. And this is, I believe, the second or it might be the third listening session that USCIS has held on the RIA since it was passed. This is not going to be a give and take or a dialogue between the public and the agency, but this is going to be another listening session. And we can expect that the agency will share with the public some of its activities and maybe some statistics, but it won't be a real sort of conversation. But so how should we best leverage this opportunity as members of the public? I think that first, I'm hoping to hear that we really do have this need for more of a meaningful give and take. It's too important to resolve by litigation and other means these big unanswered questions about how this new law is going to be interpreted and implemented. It's more efficient, I would say, to have these dialogues in advance of interpretations and policies and website postings that tell us what the agency's interpretations are going to be. And certainly not for every issue, but for certain high impact interpretations affecting program-wide uses, certainly advanced engagements are going to be more efficient ways to proceed than by litigation. We're hopefully going to be hearing a request for a plan for reduction in processing times. We are looking at 80 months of reported processing times on mainland Chinese EB-5 petitions and over 50 months in processing times on non-mainland China petitions. This is just simply unreasonably too long. And we know that the agency is struggling with backlog reduction and reducing processing times overall. And I think it's making great strides in that. We need to have those strides be taken in the EB-5 space as well. Why don't we go into the Bering II settlement agreement and summarizing the aspects of that settlement agreement. And I do expect that we'll be hearing some questions about how the agreement is going to be implemented. And I have some questions on that front as well. So the court, the Bering court, enjoined the service, meaning it prohibited the service from, quote, treating as deauthorized the previously designated regional centers based on its almost certainly erroneous interpretation of the Integrity Act. So again, not to beat a dead horse, but rather than interpreting almost certainly erroneously the Integrity Act, why not have advanced dialogue and look for the best interpretation before litigation? Terms of the settlement agreement. We have some definitions, and we have a lot of treatment on previously approved regional centers, right? Because the litigation was brought because the service interpreted the RIA to say that previously approved regional centers no longer retain their designations, but instead had to make a new filing and await adjudication of that new filing before beginning to operate again. And this again ties into the extremely lengthy processing times for EB-5 adjudications overall. So pursuant to the settlement order, previously approved regional centers do not need to seek reauthorization. They don't lose their designation. Previously approved regional centers, or PARCs, though, must file a new I-956 by December 29th. And as an amendment to their existing designations, and this makes sense logically, to continue to maintain their status as an approved regional center. Regional centers previously approved that had already submitted 956s don't need to resubmit. Previously approved regional centers that had submitted the 9526s before the effective date of the settlement agreement may interfile. They don't need to file again. They just need to make supplemental filings, which is what an interfiling is, if they need to bring their 956 in line with the terms of the settlement order. So for example, if they ticked initial designation on the 956 because it wasn't clear how to describe the 956 filing, even though they were previously approved. It is a new form. Now we're instructed to file the 956 as an amendment. So changing that tick mark from initial to amendment would be an interfiling to conform to the terms of the settlement agreement. So that should be done as an interfiling. The settlement agreement says. Previously approved regional centers don't need to receive an approval of the 956 to continue operating. Previously approved regional centers must still file the 956F. And I've gotten inquiries on this. There's been some confusion. I don't think there's any confusion on this point. It's clear in the RIA itself and reaffirmed in this settlement agreement. Even though regional centers maintain their designations, they must still file the 956F. There was a question as to whether a 956F was required for previously approved exemplars pre-RIA. So these are 924 approvals pre-RIA. That's been answered in the settlement agreement. Those pre-RIA exemplars must still file the 956F. However, pursuant to the RIA, the previously approved exemplar is binding on the subsequently filed 956F, says the settlement agreement. However, here's a question. The settlement agreement does not confirm that that previously approved exemplar is further binding on associated petitions. And that is very, very clear in the RIA itself, which says that the previously approved exemplar shall be binding for purposes of the adjudication of subsequent petitions seeking classification. So while it's not necessary, I would argue, for the settlement agreement or anything else to confirm that the pre-RIA exemplars are binding on associated petitions, it would be nice to have that clarification. And I looked for it, particularly since the settlement agreement confirmed that the 956F was binding, or the exemplar was binding on the 956F. The agreement does make clear that even on pre-RIA exemplars, that the new terms of the RIA, by which I think we can assume the integrity measures still apply to the regional center and to the project for purposes of subsequent reporting requirements, for example. Based on that pre-RIA exemplar, if an investor filed a 956 or 956E without a 956F receipt, that's okay. Thinking that because it's a pre-RIA approved exemplar, that perhaps a 956F was not required. It's okay. It is required, but those petitions can be withdrawn and refiled, or they can be kept in queue and a 956F receipt simply interfiled with that previously filed 526. And there would be a retention of priority date in those instances. There's also important clarification about the 956F receipt itself. So there was a lot of discussion and concern about the need for the inclusion of a 956F in petitions in I-526's 526Es as the form was released later. And that's because same issue, the delays in the receiving process. The settlement order agreement, rather, it makes clear that the petitioner does not need to wait for that formal 956F receipt. Substitutes will do in the form, if 10 days have passed since the 956F was physically delivered to the correct address, then in lieu of the formal 956F receipt, the petition can be filed with the lockbox acknowledgement of the case being received, which comes earlier, which usually within a week, and the first 6 pages of the Form 956F itself. And the first 6 pages are the pages of the 956 that describe the project. Also, proof of the cashed 956F filing fee will serve in lieu of the 956F receipt as well. So in other words, the fact that the 956F receipt itself is not forthcoming does not need to delay or invalidate the 956E file, the 9526E filing. It can be filed with these substitutes for the formal receipt. Moreover, for petitions filed before the settlement agreement, but after the court order, the injunction, which came down around June 24th. So for petitions filed between June 24th and August and September 1, when the settlement agreement was adopted and became effective, those petitions still benefit from this order, even if they were filed without the formal receipt. These petitions can proceed with the filing, with the interfiling of a 956F receipt. Okay. The settlement order also, I keep calling it the settlement order, it's the settlement agreement. The settlement agreement also makes clear that a previously approved regional center doesn't have to file the 956 by December 29th if it doesn't wish to continue operating as a regional center and continue to receive investor petitions. It can just discontinue its designation, and the associated 526s and the 829s will continue to be adjudicated, and they won't be denied solely based on the lack of a regional center associated with them. And moreover, the provisions protecting good faith investors under subparagraph M will continue to operate. Now, subparagraph M, by its terms, applies only to investors affected by terminated and debarred regional centers and new commercial enterprises. So that provision may not technically apply to investors who are associated with regional centers that are just no longer operating. But these are questions that remain to be answered as facts unfold. Well, I hope that summary of the Bearing to Litigation Settlement Agreement and some of the points that I hope we'll be listening for and asking the service to respond to, specifically the processing times, will be helpful to our audience in having a greater understanding and level of engagement on their parts with the listening session that's coming in just a week, October 19th, 2 p.m. Eastern Time. Feel free to send any questions or comments about what you would like to see, questions that you have, what you would like to hear at the listening engagement to contact at Carolyn Lee Pllc. It's always interesting to hear what's on the minds of folks who are listening to the agency speak about EB5. And until next time, be well, and we will have another webcast very, very soon. Thank you for being with us.